it's interesting, but it's not only the extremely wealthy who are worth going after anymore. A potential target these days is anyone who has a nest egg for their savings or something put away for their kids' education. It used to be thought that the deep pocket was a big bank or an insurance company or a big company with lots of money to be able to pay off a judgment. But unfortunately, that's no longer the case. We've got 1 million lawyers in the country, and every year 100,000 new lawyers graduate from law school and set up a practice. And the problem is that there aren't enough good cases to go around. A good case involves serious injury from a defendant with lots of assets or lots of insurance. And the problem for lawyers is that most of the good cases go to a relatively small group of trial attorneys who have experience winning multi-million-dollar verdicts. There's a good reason for this. If you're injured by an Exxon gasoline truck crashing through your house, you want the best trial lawyer that you can find. Since all contingent fee attorneys charge the same 33 to 40% of the award, why not get the best? The best and the most experienced lawyer in the country costs exactly the same as your cousin Filbert, who's never tried a case. So what are the rest of the lawyers going to do? What about the other 95% of the trial lawyers who are not the best attorneys and not at the top of their profession? How are they going to feed their family? His chance of getting your case against Exxon are about the same as hitting the lottery. So most lawyers make a living by filing bad cases with bad facts and trying to get some money or some savings from a potential defendant with even modest assets. The lawyer's bet is that by filing the case, he'll be able to squeeze a settlement or play lawsuit roulette with the jury. It isn't that hard to confuse a jury or to sway them with emotional or even irrational arguments, and anyone that saw the result in the O.J. Simpson criminal case knows that that type of result isn't unusual. A significant amount of the time, a sympathetic plaintiff will prevail against a wealthy or even a comparatively wealthy defendant in cases which appear to be absurd, illogical, and utterly without merit. Lawyers exploit the weakness in the legal system for their own advantage. Let me give you an example. A wealthy client named Alan invested $10,000 in a software development company owned by an old college acquaintance. And he put up the money as a favor to his friend. He wasn't interested in making money from the investment. He didn't want to participate in the operations of the company at all. He received 2% of the stock, and he took the certificates and he put them in his safe deposit. And he didn't think about it again. He didn't think about it for several years until he was served with a lawsuit for $25 million. The suit alleged that the software company had breached a contract to develop software for a particular customer, and that the failure to deliver the program on time had cost that customer to lose millions of dollars. They were now suing for $25 million, and Alan was named as a defendant in the case together with the company. But since the company had very few assets, it was primarily a service business with nothing substantial to take, it was clear that the real target in the case was Alan and not the company. Alan had $3 million in a brokerage account, and this was the prize that the plaintiffs were after. The case was very disturbing because from a legal standpoint, Alan really had no legal liability. As a minority shareholder, not as an officer or director, he didn't participate in any of the business decisions of the company. He really had no input or responsibility inside the company. The case had been filed solely because the other side had run an asset search on all of the shareholders looking for a shakedown target, and they hit the jackpot when they found Alan's accounts. The attorney for the other side later admitted to us that had they not found Alan's accounts, they wouldn't have filed the case. They had nobody else to go after, but now they had a perfect setup. Although Alan had no legal liability, what happens in court is often different than what we think should happen. As a named defendant in the case now, Alan had a very difficult choice. He could fight the case and if he lost, then there was a risk that he could lose damages of several $1 million and lose everything that he had. If he, even if he won, he would still have $100,000 to $150,000 in legal fees, and it would absorb much of his time and emotion over the coming years. See, the lawyer for the other side knew exactly how to play the game by creating this risk and this uncertainty in Alan's life. And after several months of painful negotiation, Alan ended up settling the case for $450,000. It was very hard for him to pay the money. From a financial standpoint, it represented a lot of his net worth. And from an emotional standpoint, he knew that he had done nothing wrong. But he was trapped and outmaneuvered in this situation, and he had no choice. So by holding his money in an unprotected form, easily discoverable and reachable, he was a vulnerable target. And once spotted, the legal sharks moved in on him, and then it was too late. The case provides a very frightening example of the deep pocket litigation threat. Easy access to financial information allows unscrupulous plaintiffs and their lawyers to extort money from unsuspecting and defenseless victims. Let me give you one more example. Mrs. Drake was a 75-year-old widow, and she sold a duplex that she had owned in California for many years. She sold it for $200,000 and used the money, which was her life savings, to buy a new condominium in Arizona, and she moved there. Her only income was Social Security and of about $1,200 a month, which she felt would give her enough to pay her living expenses and live a decent retirement. 3 years after the sale, the real estate market in California collapsed, and the value of the duplex that she had sold dropped by half. That shouldn't have mattered to Mrs. Drake, since she had sold the property 3 years earlier. The new buyer was just unlucky when he lost his money in the real estate market. But that's not how it works anymore. The buyer sued Mrs. Drake in California, claiming that she had failed to disclose defects in the property. None of the allegations were true. The reality was that the buyer had lost money on the sale, and he now wanted it back. So he asked the court to rescind the contract and get back his $200,000 plus interest on. The lawsuit clearly placed Mrs. Drake in a terrible position. To defend the case, she'd have to hire an attorney, and these types of cases are very expensive to defend. She was told that legal fees would run between $25,000 and $50,000, money that she clearly couldn't afford to lose here. The buyer's attorney, on the other hand, was working on a contingent fee basis, which meant that they really had nothing to lose at all. And so they had nothing to lose by pursuing the lawsuit. So rather than risk losing her home and the rest of her savings, and knowing that the litigation costs alone could wipe her out, she settled the case for $70,000. She borrowed the money against the equity in her condominium, and now she uses most of her Social Security check to make the monthly mortgage payments on that amount. So instead of a comfortable retirement enjoying her life, she now leads a Spartan existence each month. What did she do wrong in this case? She sold her property at the top of the market. She should be rewarded for her business savvy. But instead, she was an easy and a vulnerable target, and the buyer and the lawyer managed to extort from her most of her life savings. What should she have done instead? The outcome of the case likely would have been different had she used a privacy and asset protection strategy to hold the Arizona condominium. Her ownership of the property would have been concealed so that the lawyer for the duplex buyer, when he did an asset search to see what she owned, would have come up with nothing. Additionally, the arrangement worked so well from an asset protection standpoint that even if Mrs. Drake had been sued by the buyer, and if she had lost, her property would have been protected against the judgment. Privacy for assets plus legal protection is usually a plan which defeats these type of extortion attempts. There's two key points, I think, that are illustrated by these cases. First, the nature and extent of your assets can be easily located by the investigation firms. And second, because of the nature of our legal system, findable and reachable assets creates a magnet for potential lawsuits looking for a payday at your expense.